Hello everybody, welcome to iExamBee's Legalbee. This is Amrita, your law faculty here at iExamBee. Embrace the iExamBee learning experience with us. In this video today, I am going to continue with a series of 300 important questions exclusively for the IBPS SO Law Officer and UIIC Legal Exam 2024, which are the upcoming examinations. For all such kind of videos, stay tuned to Legalbee, download our app also and prepare 50% faster with us for jobs. For different exams, you can also check out our online courses on www.iexambee.com. In case of queries, you can write an email to us on hello@iexambee.com or you can call us on this number 9205524028. Today we will be continuing with this series, and the topic that I have taken up for this video is going to be Companies Act, which is relevant for both the examinations. Companies Act के important questions हम लोग इस वीडियो में डिस्कस करने वाले हैं. It is having a good weightage also. A small company is a company whose paid up capital and turnover shall exceed rupees 2 crores and rupees 10 crores, 4 crores and rupees 40 crores, not exceed rupees 4 crores 40 crores, not exceed rupees 2 crores and rupees 20 crores, be such as the company may decide from time to time. So a small company is a company whose paid up capital and turnover shall. Answer is C, not exceed rupees 4 crores and rupees 40 crores. Company Specification of Definition Details Rules 2014. Rule number 2, 1T talks about for the purposes of subclause 1 and subclause 2 of clause 85 of section 2 of the Act, the paid up capital and turnover of a small company shall not exceed rupees 4 crore and rupees 40 crores respectively. ये ऐसे kinds of company, उनके capitals, ये सब important areas होते हैं from where we can expect questions. A public company is a company which has a minimum paid up share capital as may be prescribed, no minimum paid up capital requirement, 5 lakh rupees or 50 crore paid up capital, 1 lakh rupees or such higher paid up capital as may be prescribed, 5 lakh rupees or such higher paid up capital as may be prescribed. Correct answer is B. No minimum paid up capital requirement is there. Section 2 clause 71 deals with public company, which means a company which is not a private company and has a minimum paid up share capital as may be prescribed. Since there is no prescribed amount, therefore there is no minimum paid up capital requirement. A private company can issue shares through bonus issue, private offer, issue of securities, initial public offer, all of the above. So private company can issue shares through what? Correct answer over here is A, bonus issue. Section 23 deals with public offer and private placement. A private company may issue securities by way of rights issue or bonus issue in accordance with the provisions of this Act, or through private placement by complying with the provisions of Part 2 of this chapter. The issue of shares by a company on a discount is prohibited, and thus it shall be void, illegal, voidable, unenforceable, unauthorized. So the issue of shares by a company on a discount is prohibited, and thus it shall be what? Void, illegal, voidable, unenforceable or unauthorized. What is the correct answer over here? Correct answer is A, it will be void. Section 53, prohibition on issue of shares at discount. Clause 2, any share issued by a company at a discount shall be void. In case the office of any whole-time key managerial personnel is vacated, the resulting vacancy shall be filled up by the board at a meeting of the board within a period of dash from the date of such vacancy. That will be 15 days, 120 days, 6 months, 1 year, none of the above. So that will be within a period of how many days or months from the date of such vacancy? Correct answer is C, 6 months. Section 203, appointment of key managerial personnel, clause 4, if the office of any whole-time key managerial personnel is vacated, the resulting vacancy shall be filled up by the board at a meeting of the board within a period of 6 months from the date of such vacancy. Which of the following is true relating to red herring prospectus? It is issued prior to the issue of a prospectus. It shall carry the same obligations as are applicable to a prospectus. It shall be filed with the registrar at least 3 days prior to the opening of the subscription list and the offer. All A, B and C both A and C. So which of the following is true, they are asking, relating to red herring prospectus. These prospectus and relating questions, ये तो आप मान के चलो कि ये आएंगे ही. All these are very important and expected questions from company law. Correct answer is D. All A, B and C are true about red herring prospectus. It is covered under section 32 of the Companies Act. A person shall be eligible for appointment as an auditor of a company only if he is a cost accountant, chartered accountant in practice, any person as the board may decide, either A or B or C or D. So a person shall be eligible for appointment as an auditor of a company only if he is a, correct answer is C, chartered accountant in practice. Section 141, eligibility, qualifications and disqualifications of auditors. So a person shall be eligible for appointment as an auditor of a company only if he is a chartered accountant in practice. Clause 1 से directly pick किया है. 8th question. What is the time period within which a copy of the financial statement, including consolidated financial statement if any, duly adopted at the annual general meeting of the company, shall be filed with the registrar? That time period is asked. 15 days, 30 days, 45 days, 60 days, 90 days. Direct question है, easy भी है. Correct answer is B, 30 days. Section 137 deals with copy of financial statement to be filed with the registrar. That is a copy of financial statement including what? Consolidated financial statement if any, along with all the documents which are required to be or attached to such financial statements under the Act, duly adopted at the annual general meeting of the company. It shall be filed with the registrar within 30 days of the date of annual general meeting. What is the minimum number of directors which a one-person company can have? 1, 2, 3, 15. No such requirement is there. So what is the minimum number of directors in a one-person company? That has been asked over here. One-person company में one director ही रहेगा. Name also suggests this. This is actually a very easy question. Section 149, company to have board of directors. Every company shall have a board of directors consisting of individuals as directors, and it shall have a minimum number of 3 directors in a public company, 2 directors in a private company, and 1 director in a one-person company. Maximum of 15 directors. Company may appoint more than 15 after passing special resolution. So, and that one shall have at least 1 woman director should be there. So this is section 149. ये जितना भी first clause है, ये पूरा का पूरा बहुत important है. यहाँ से आप काफी questions expect कर सकते हो. Be very thoroughly prepared with this basic. So the correct answer is 1 over here. The articles of company may confer on its board of directors the power to appoint any person other than a person who fails to get appointed as a director in a general meeting as an additional director at any time, who shall hold office up to the date of next AGM till the last date on which the AGM should have been held, either A or B, whichever is earlier, either A or B, whichever is later, at the discretion of the board of directors. Correct answer over here is C, either A or B, whichever is earlier. Section 161 deals with appointment of additional directors, alternate directors and nominee directors. So from this first clause itself directly the question is picked and the answer is either A or B. Up to the date of next annual general meeting or till the last date on which the annual general meeting should have been held. Central government shall dash from the receipt of the application under section 153 allot a director identification number to an applicant in such a manner as may be prescribed within 7 days, within 15 days, within 1 month, within 120 days, within such time period as the central government may prescribe. So what is being asked over here? Central government shall, within how many days from receipt of application, allot a director identification number? Simple. Correct answer is within 1 month. Answer is C. Section 154 deals with allotment of director identification number, that is dealing with this particular point. No company shall appoint or reappoint any person as its managing director, whole-time director or manager for a term exceeding 2 years, a term exceeding 5 years at a time भी दिया हुआ है, focus on that, a term exceeding 15 years at a time, term as may be prescribed for the same, none of the above. Answer is A, term exceeding 5 years at a time. So as for section 196, appointment of managing director, whole-time director or manager, no company shall appoint or reappoint any person as its managing director, whole-time director or a manager for a term exceeding 5 years at a time. Actually here there is a typographical error. Technically the correct answer is B over here. Please note it down. A term exceeding 5 years at a time is the correct answer as per section 196. This is the correct answer. Solution is given correct. This is the option name. On an application made to dash by the company, a company limited by shares or limited by guarantee and having a share capital may by a special resolution reduce the share capital. Before which authority you can make that application? NCLAT, tribunal, central government, appropriate authority, registrar of companies. किसके पास आप ये application file कर सकते हो? Correct answer is B, tribunal. Section 66, reduction of share capital subject to confirmation by the tribunal on an application by company limited by shares or limited by guarantee and having a share capital may by a special resolution reduce the share capital in any manner and in any particular. And this we have taken the relevant part only. So section 66 deals with this point and it will be subjected to confirmation by the tribunal. So that is definitely, don't get confused with this. This is NCLAT, means this is the appellate tribunal. NCLT की बात हो रही है यहाँ पे. ये confuse करने के लिए आपको ऐसे दिया गया है. Which of the following amount shall be credited to Investor Education and Protection Fund? Amount given by central government by way of grants, donations given by central government, state government and companies or any other institution, application money received by companies for allotment of any securities and due for refund. All of the above, both A and B. So which of the following amounts shall be credited to Investor Education Protection Fund? That has been asked. Correct answer is D, all of the above. Section 125 deals with this Investor Education and Protection Fund. What shall be the effect of a registration of a company? Common seal, perpetual succession, power to acquire, hold and dispose of property. All of the above, both B and C, that's perpetual succession and power to acquire, hold and dispose of property. So the effect of registration of a company, what effect it is going to have, that is asked over here. Correct answer is E, both B and C. Section 9 covers this effect of registration. As per that provision, from the date of incorporation mentioned in certificate of incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum, capable of exercising all of the functions of an incorporated company under this act and having perpetual succession, power to acquire, hold and dispose of property, both movable, immovable, tangible, intangible, to contract and to sue and be sued by the said name. So what is the correct answer? Both B and C, that is perpetual succession, power to acquire, hold and dispose of property. For more such kind of questions, content and videos, stay tuned with Legalbee. Prepare 50% faster with us at IXAM. Thank you everybody. Have a good day.